It's great to be here. I can't wait to talk more about this campaign, which is really good.
Programming. My intention is to bring my experience as well.
I would have moments where I would just not be okay around people.
As a social worker, I have always wanted to impact people and help.
Some of our young people get trapped in that pipeline at 16.
Has a mental health disorder and or diagnosis. When he or she has an episode, like they're not even conscious.
Too, to see, okay, how are we taking care of these human bodies behind bars?
Let's invest in people and not prisons. Welcome back to the podcast. We have the pleasure of having attorney Jeffrey Berman with us. And one of the things that Jeffrey Berman is going to do for us is give us, first and foremost, the landscape of, the Treatment Not Jail Act. How did it start? Why did it start?
So in 2009, there was drug law reform in New York State. And out of that came something called judicial diversion. Judicial diversion is currently the only law that permits judges to offer court-mandated treatment to people with substance use disorders as an alternative to incarceration, independent of the prosecutor. Judicial diversion is drug court. So with judicial diversion, drug courts were enacted throughout the state. But 13 years later, it's clear that the current law is woefully deficient in several respects. First, the statute limits eligibility to only a very narrow and arbitrary list of offenses, all of which are low-level nonviolent drug and theft-related charges. Second, the statute is primarily concerned with addressing underlying substance use or alcoholism disorders. So even when a person is otherwise eligible for drug courts often reject that person with serious mental health conditions or an intellectual or developmental disability because substance use is not the primary diagnosis. And we also see rejections of candidates for drug court when they have a serious mental health condition and the court feels that their court is not going to be in a position to best support that individual. So our clients with mental health conditions, again, they're routinely rejected by drug courts because they don't feel they're equipped to support people with a dual diagnosis, especially with diagnoses like schizophrenia, schizoaffective disorder, and bipolar disorder. Then what happens is the case is kicked back to prosecutors who serve as gatekeepers as to who can be accepted into one of the state's 30 ad hoc mental health courts. And when I say ad hoc, what I mean is that these are not codified into law. They were created by the county in which the mental health court is located. And we know that almost half of the New York State jail and prison population, which is over 30,000 people, lives with a mental health diagnosis or substance use disorder. A great majority of these drug and mental health court referrals throughout the state end in carceral dispositions. I can also tell you that the drug courts do not allow people to be accepted if they are charged with a violent offense. And if they have a prior violent felony within the last 10 years, then prosecutorial consent or gatekeeping is required. Now that is a skewed way of looking at things because being accused of a violent charge does not mean that the person will benefit from treatment or that allowing the person to participate in treatment will make the community less safe. And why do so many people embrace this false narrative that incarceration protects our communities? Well, many wrongly believe that people with mental illness are more likely to commit violent acts. The truth is that these individuals are more likely than the general are no more likely, than the general public to engage in an act of violence. And we know, for example, that that people with mental health conditions are 10 times more likely to be the victims rather than the perpetrators of a violent act. But unfortunately, for the tens of thousands of justice-involved New Yorkers seeking admission into a mental health court, this perception often precludes them from accessing the needed treatment, which continues the vicious cycle of further destabilizing and traumatizing and bringing about an increase in recidivism and a decrease in protecting our communities. So the Treatment Not Jail Act will significantly expand upon the 2009 Drug Court Judicial Diversion Statute. So in many very meaningful ways. First off, there are not going to be any charge restrictions. So you can be charged with any crime under the penal law to become eligible for judicial diversion, the new judicial diversion, which is the Treatment Not Jail Act. That doesn't mean that the person is going to be accepted for judicial diversion. It just means that they are eligible so long as after a substantive clinical evaluation completed by a psychologist, a licensed social worker, or a psychiatrist, or another healthcare provider, so long as that evaluation shows that the individual lives with a mental health condition or a neurocognitive disability or a substance use disorder, and that this contributed to this person's involvement in the criminal legal system, then it's up to the judge to make a decision about whether or not the person should be accepted into judicial diversion after engaging in a public safety analysis. So this is one of the key components of the Treatment Not Jail Act, which is taking away the charge restrictions. Treatment Not Jail also does not require a plea of guilty in order to assuming somebody is accepted into Treatment Not Jail, the guilty plea requirement is no longer there. So why is removing the guilty plea requirement important? Treatment Not Jail will expedite access to treatment and ensure that people don't languish in jail for months or even years waiting for their cases to resolve before they can access necessary health care. Currently, in Manhattan, for example, where I practice, the average wait time from arrest to release into the ad hoc mental health court that exists in Manhattan is a total of 331 days. So offering treatment without an upfront plea addresses the coercive nature of plea bargaining and is going to expedite the process, and also acknowledges that poor people, particularly people of color, often plead guilty to crimes simply because they can't afford bail. The guilty plea requirement also creates unequal access to treatment. So for non-citizens, the mere admission to a criminal charge can result in deportation, regardless of whether the case is ultimately dismissed. Additionally, people with open pleas or criminal convictions face barriers with employment, licensing, housing, education. And these are the very systems that can offer the stability and support that people need in order to stay out of the criminal legal system. So Treatment Not Jail changes the narrative of how we view justice by not requiring our clients to plead guilty in order to access treatment. The Treatment Not Jail also embraces a harm reduction model. Harm reduction is about keeping people alive, because if we can keep people alive, then we are giving them the opportunity to access help. The use of jail does nothing but affirm that a person is a criminal because of their health condition. It is the very stereotype that drug and mental health courts were designed to reject. Treatment Not Jail shifts the court's response from being punitive to a safer and smarter and more humane one, rooted in proven principles of harm reduction and person-centered treatment plans. When it comes to treatment, Treatment Not Jail is about learning from the research, as great strides have been made in identifying evidence-based treatment, which is notably not being used in many problem-solving courts today. Harm reduction will reduce dangerous overdoses and deaths related to substance use. It recognizes that cold turkey approaches to treating substance use is dangerous and counterproductive to meaningful and safe recovery. Finally, and this is so critically important, diversion courts must leave treatment decisions to the clinicians, doctors, and social workers who treat and best understand our clients. This means that judges and prosecutors or defense attorneys should not be making decisions about what medications our clients may take while they're in treatment and what treatment plan should look like. If a medical doctor, knowing our client's history, recommends pain medication to treat our client's chronic medical condition, then a judge should not overrule that. And this is the Treatment Not Jail Act. Currently, judges are making medical decisions that they're not qualified to make. And Treatment Not Jail will put those decisions into the hands of clinicians. And one final very exciting aspect of Treatment Not Jail is this idea of procedural justice. Procedural justice is this idea that when people become involved in the criminal legal system, they trust the various actors that they're going to come across during their experience. They trust the judge, they trust the court, they're treated with respect, they're treated with dignity. Currently, when our clients enter into the courthouse, from the moment they walk through those doors, they are not treated with respect. They are referred to in the courtroom as a defendant. If they're in jail and they're brought into the courtroom from the jail, they're referred to as the body. The jail cell behind the courtroom is referred to as a pen, like a slave pen or a pig pen. It's really amazing that anybody could feel that our clients would trust the process when they're being treated that way. So Treatment Not Jail is going to require that all of the actors, the players involved in diversion are going to be trained annually in the tenets of procedural justice. So these are some of the key components of Treatment Not Jail, Mark.
So Jeff, I want to back up a little bit because
Sure.
I want to make sure I'm clear on what you said earlier. A person that has a mental health diagnosis is excluded from participating in diversion court?
So currently, the only existing law in New York State that gives a judge discretion over a prosecutor's objection to order court-mandated treatment is the drug court statute. And that's called judicial diversion. Treatment Not Jail, it's still going to be called judicial diversion. It's just an expanded judicial diversion from what currently exists. So the drug court statute, which is criminal law 216, does permit people with co-occurring diagnoses to be admitted into drug court so long as they are otherwise eligible, meaning they're charged with an enumerated offense under Article 216, after a clinical evaluation, it's determined that the substance use disorder contributed or played a primary role in the allegations, in the criminal allegations. So where mental health or a mental health diagnosis is the primary condition, that person would be rejected from drug court. Where somebody has a serious mental health condition like schizophrenia or schizoaffective disorder or bipolar disorder, what we're seeing happening throughout the state is that drug courts feel that they are not equipped to support people with these behavioral health conditions. And so they kick it out back to the prosecutor, who then serves as gatekeeper to determine whether that individual could be accepted into a mental health court.
So basically, if I'm understanding you correctly, if an individual is developmentally disabled and has the mindset of a 3-year-old, and he or she is in their 30s, and they don't have a substance use disorder, they are denied the opportunity to participate in the judicial diversion?
That's right. If somebody does not have a substance use disorder and they're not charged with a very, there's very few charges under the penal law that qualify somebody for drug court. So if they're not charged with an enumerated offense, they don't have a substance use disorder, they would not qualify for drug court. And then the prosecutor would serve as gatekeeper to determine whether that individual could be diverted into into a mental health court if that jurisdiction even has one. And like I stated earlier, there are approximately 30 ad hoc mental health courts in the state of New York. New York's a big state. That's not a lot of mental health courts. So, and a lot of people who are trying to get into mental health court are not being accepted. Some jurisdictions, including in the giant city of New York, have caps on how many people can even be accepted into the mental health court. For example, in Manhattan, there is a cap of 50 people only, and only 50 people at one time can receive treatment in the Manhattan mental health court. So what's happening to the rest of those people? They are
next question, Jeff.
Well, they do have a veterans court. So if you're a veteran, you might be eligible for that. There's also an alternative to incarceration court in Manhattan. You might be eligible for that. But most jurisdictions don't have all of these problem-solving courts. Most jurisdictions do not have a mental health court or a veterans court or some other kind of problem-solving court. So if there is no mental health court, or if you're rejected from mental health court, then the options that are left are to go to trial and take your chances at trial, or to take a plea and get the least amount of jail time that you can get. And that's what's happening very, very frequently to people who become justice involved in New York.
All right, last question, Jeff, because I really want our audience to understand and grasp what I hear you saying. And I hear you saying that someone that has the mindset of a 2-year-old child that is in their 30s and they commit an offense 99.9% of the time, we're going to incarcerate them as opposed to treat them?
I've had represented many clients over the years who are on the autism spectrum, who have mild, moderate, or even severe intellectual or neurocognitive disabilities, and many of them end up in jail. Many of them end up with sentences that do not involve treatment, but something more like probation. They're not being helped. So I can't speak to every single ad hoc mental health court in New York State, except to say that my experience is that people with intellectual or neurocognitive disabilities are seldomly accepted into the mental health court where I practice. I'm not saying it never happens, but it's not something that regularly happens.
So, Jeff, if we are incarcerating people that have these disabilities that you just delineated, how does that impact the safety of the community and public safety?
That's the big question, Mark, because there is this belief, there's this false narrative that people buy into, which is that incarcerating members of our community who are involved in the criminal legal system makes others in the community safer. And these narratives rely on our community's fears by repeating this fallacy over and over again. However, a robust body of research analyzing the impact of incarceration in New York and nationwide indicate that being in jail and prison makes someone more likely to reoffend. The reasons for this are not hard to identify, Mark. Incarceration is incredibly destabilizing, traumatizing, and filled with violence and drug use. The people we send to jails and prisons are often left to languish during their time inside with inadequate mental health treatment and medical care. And once their period of incarceration ends, these individuals are released back into the community without stable housing, without medical care, without mental health services or rehabilitation systems in place. They're expected to gain employment, stable housing and benefits while navigating the adverse collateral consequences of now having a criminal conviction. This increases the risks for substance use, exacerbated and untreated mental health conditions. It's a revolving door for visits to the psychiatric emergency room or inpatient psychiatric admissions in a hospital, and inevitably further involvement in the criminal legal system, all at the expense of public safety.
Thank you. So, Jeff, share with us some of the highlights of the Treatment Not Jail Coalition.
Of the coalition, or of?
Yeah, and of the bill, of the coalition and the bill. Share some highlights.
Well, the coalition, it's very, very exciting. The coalition consists of practitioners who, in New York State, mental health specialists, many different nonprofit organizations that get involved in the criminal legal system and are advocating for change. We are led by two dynamic legislators. Senator Jessica Ramos is our sponsor on the Senate side, and Farah Supran Forrest is our sponsor on the Assembly side. We have almost, or I would say actually over, if I'm not mistaken, 50 co-sponsors, and we have not even held a hearing on the bill yet. So this is a bill that has generated considerable excitement in New York. There have been, as you may know, a lot written about the bill in the news, in the media. When you turn on the news and you see a story about some alleged violent act, and then everybody is understandably upset. Again, the instinct by many is to say, we need to make our community safer by putting people in jail and putting people away. But that is not the solution. And the solution is a smart solution, and we need to get to the very heart of why people are even getting involved in the criminal legal system. My clients, and I've been practicing for 25 years now, proudly as a public defender at the Legal Aid Society. My clients have been failed throughout their lives. They've been failed with education. They weren't given special education services when they should have been given them, or they weren't adequate. They grew up in shelters or in homes that were filled with violence or trauma. They were witnesses to violence. They got involved in the child welfare system. So these systems have failed our clients, and treatment, not jail. The philosophy of this bill is that the criminal legal system cannot fail them again. If somebody gets involved in the criminal legal system because of a health condition, then we need to treat what is happening with them in the criminal legal system as a matter of public health equity. In terms of some of the main points of the bill, some of the exciting parts of the bill, we discussed earlier that this bill does not have any charge restrictions. It does not require a plea of guilty in order to access treatment, healthcare treatment. The bill embraces a harm reduction model. The bill embraces procedural justice. The bill also offers due process protections that don't currently exist for participants in judicial diversion. Currently, if somebody is accused of violating the terms of their contract, then they're not entitled even to a hearing to determine whether there was a violation. So this is something that is a big part of the Treatment Not Jail Act legislation as well.
So Jeff, one more question I have for you. Why should the community support this bill?
The community should support this bill because you don't have to be a person of color, somebody of a certain socioeconomic status, of a certain political party to have either experienced or know somebody who lives with a mental health condition. And many of us, no matter who we are or where we come from, know people in our family or people that we're close with who were so unfortunate to become involved in the criminal legal system. The public should support this bill because we care about our communities. We care about making our communities safer. Right now, it costs $556,000 per person per year to incarcerate an individual at Rikers Island. Just imagine if we took all of that money and we invested it in housing and community programming, and the programming that's going to provide treatment to our clients who are so unfortunate as to get involved in the criminal legal system and need to ask for judicial diversion.
So you're saying that this treatment, not jail bill that all of us are in support of, would create a safer space for those returning to the community, those who are in the community, and those who we are making the decision to extract from the community.
That's right. Listen, I wish that people weren't getting arrested. I wish people weren't getting entrenched in the criminal legal system. I wish that didn't happen. We need to invest in our communities. So that happens far less than it happens now. But again, if somebody does get arrested because of a health condition, which contributed to the charges, and they are fortunate enough to be accepted into a judicial diversion program, all the data shows that people who successfully complete mental health or drug diversion courts, should their jurisdiction have a drug court, if that's what it is, these people have a significantly lower rate of recidivism than people who are coming out of jail. So investing in mental health courts, community treatment, and housing is a far more cost-effective use of state resources than incarceration too.
So actually, this investment is an investment in public health and the public health crisis that we are currently experiencing in New York and throughout the country.
Absolutely. I think, right now we know that over 50% of people who are incarcerated in New York State have a mental health condition or a substance use disorder. What does that tell you? When we know that we have over 30,000 people currently incarcerated in New York State, and half of them have a mental health diagnosis or a substance use disorder, and they're going to come out of prison or they're going to come out of jail without all the supports that I just mentioned: healthcare, medical care, benefits, family supports, housing. It's really just a recipe for disaster for that person. It's very, very difficult to stabilize under those conditions.
So actually, what we're doing is creating our own revolving door.
We're stopping, but right, we are. It is right. It's totally a revolving door. Mark, you know that because you work in hospitals, and you see a lot of the same people there in your job, even after they've come out of jail or go back to jail. They're back in the hospital. They go to the hospital to get their medications because they don't have a mental health provider in the community to give it to them consistently. But because they're homeless and they don't have community supports, once they get out of the hospital, it's very, very difficult for them to be stable and to be consistent. The mental health courts where I practice in New York City work with intensive mental health treatment providers like ACT teams, like intensive mobile treatment teams. These types of treatment teams are unbelievably effective. And the recidivism rate for people who are part of these teams is very, very low. And the hospitalization rate is very, very low. So what we need is consistent, robust community treatment, not Band-Aids.
I want to thank you, Jeff, for sharing the knowledge of the landscape, dispelling some of the fear-mongering misconceptions, and overall for expressing and articulating your 25 years of experience working inside of the criminal legal system. Any final words, Jeff?
I mean, this is near and dear to me, this legislation. I have so frequently seen my clients denied the ability to be in a mental health court, even denied the opportunity to be in a drug court, because the judge is more focused on the person's record than they are on the evidence before them, which shows that they could benefit from substance use treatment.
Hey, Jeff, any final thoughts?
I mean, this is personal for me, Mark, and I know it's personal for thousands and thousands of people with lived experience that have never had the opportunity to get a chance to have treatment. I mean, I've been practicing for 25 years, and there have been so many times when I advocated so hard with prosecutors to allow my client to go into the mental health court, and they were rejected, and they didn't understand why. And then they went to prison. And I've actually, I've arrested, I've represented those clients when they came out of prison for new arrests. The cycle just continues and continues. So if we care about keeping our community safe, if we are going to respect if we're going to respect human beings and all that they have gone through in their lives, leading them to unfortunately get arrested for something, then we need to treat their involvement in the criminal legal system as a matter of public health equity.
Thank you very much, Jeffrey. That was Very well said, very well articulated, and hopefully our listeners have a different perspective on treatment, not jail, and the significance of it and the impact that it will have on public safety and our communities. Thanks again, Jeff.